Earning income. Thank you very much for joining this important and, if I may say, preliminary discussion on FTX and the insolvency that has found itself in, and the larger question of asset tracing and asset recovery mechanisms that are available to investors in the crypto industry. With us today, apart from the founder of Synergia Foundation, Toby Simon, who's sitting at the table, we have speakers whom I will introduce presently, but I also want to take a minute to acknowledge the presence of the Dutch Consul General, Mr. Heine. Thank you for joining us. The speakers and the panel that we have of eminence are and I will introduce them first and then invite them to speak in a moment. But led at the top, we have Ms. Shobana Iyer, who's a commercial barrister, arbitrator, and mediator at Swan Chambers in London. She specializes in complex cross-border commercial cases, which frequently involve issues in corporate intellectual property, technology, data protection laws, and she is presently the co-vice chair of the Legal Services Committee of the Bar Council of England and Wales, and sits on various professional committees, including CIR London, and frequently deals with legal aspects involving emerging technology. She has assisted the Bar Council response to the recent UK House of Commons ECMS Direct Committee's inquiry to the operation risks and benefit of non-fungible tokens and the wider blockchain. Shobana is also presenting the Bar Council's response to the House of Commons in the UK, which is what I just referred to on NFTs. Next up, we have Mr. Suraj Srinath, who is present in person next to me, also in black. And Suraj is a co-founder of Platter Finance. He's the entrepreneur in the room. He is a commentator on Web3, crypto, DeFi, and NFTs. He is a crypto enthusiast and believes that there will be an irretrievable move away from fiat currency towards crypto. And his organization, Platter, aims to build a curated marketplace for DeFi investment and Web3 products. Platter's platform will allow users to learn about DeFi and Web3 ecosystem, invest and track different types of DeFi products, and use Web3 products on its platform. Welcome, Suraj. Welcome, Shobana. Next up, we have the person with the most inconvenient timing on the panel, and thank you, Emmanuel Callejas, who's joining us from Guatemala City and in Guatemala. He's a partner at Carrillo and Associados, and Emmanuel is a certified fraud examiner focused on the prevention, detection, and investigation of fraud, risk management, and compliance matters. His experience includes general aspects of asset recovery, collection of evidence, and the coordination of strategies supporting local and international dispute resolutions, including cooperating with local and international forensic experts and preserving electronic information. And finally, and not at all by the least, we have Mr. Hector Spurt, partner at ECIJA, member of ICC FraudNet in Spain. Hector has more than 20 years of experience advising national and international clients in all sectors on procedural and insolvency law. He's an expert in asset tracing and recovery, civil and commercial fraud, and contentious insolvencies. He's also the Spanish representative to FraudNet, a global network of lawyers that operates under the aegis of the International Chamber of Commerce. And I suppose I should introduce myself in a sentence to say I'm Shreyas Jayasimha, an advocate, arbitrator, and mediator, and privileged to be the moderator of this panel. I run a practice in India called Arna Law and a practice in Singapore called Simha Law. I'm also the India member of ICC FraudNet, and which is why I know a couple of the speakers on the panel here. Without further ado, I would like to first invite Shobana. Shobana, if you could please explain to our audience, both the physical and virtual, kind of the present state of regulation of crypto assets in the UK, especially given your association with the Bar Council's response to the UK House of Commons ECMS Select Committee, and perhaps how this type of regulation in a common law context came to be. Over to you, Shobana.
Right. So, I presume you can hear me?
Yes.
Yes. So here in the UK, I mean, we've been through a complete turmoil, actually, with a load of consultations in this area of regulation and about balancing regulation with innovation in this context. And before I move on to the Bar Council's response, because Bar Council's response is only from the perspective of barristers, essentially, I just want to give a kind of overview about the concerns that have been impacted in this kind of area. As we know that following the crypto winter, and I think it just exacerbated even more with the FTX collapse, that we've seen a kind of a global setting or a global standards for regulating crypto assets, similar to the traditional finance. But that's also provoked industry concerns that they failed to distinguish between the sectors and the distinctions of crypto assets compared to traditional finance. And you would know that the Financial Stability Board, the FSB, has published their published the responses to their proposed framework for an international regulation of crypto assets, which it published on the 11th of October 2022. Now, the Financial Stability Board, as you know, India, UK, Singapore, US, we're all part of it, received 49 responses and aims to publish its final reports in July 2023. So we have a lot of these regulations actually just being evolved at the moment, mainly because I think the technology and everything in this area is being is also evolving. So the core components of the Financial Stability Board recommendations are to promote consistency and comprehensiveness of regulatory, supervisory and oversight of crypto activities and markets, and strengthen international cooperation and coordination and information sharing. And it also tries to highlight revised high-level recommendations for regulation and supervision of global stable coins. And I think this is where we have these kind of concerns, actually, because if we look at the first issue that I have as any kind of lawyer is, well, what are crypto assets? What is the ambit of crypto assets? And if we look at the definition from the Financial Conducts Authority, it gives the guidance, in its guidance published in January 2019, crypto assets are cryptographically secure digital representations of value or contractual rights that use some type of digital distributed ledger technology and can be transferred, stored, and traded electronically. However, they can vary significantly in rights they grant their owners as well as their actual and potential users. Now, this is kind of similar to the European Bank Authority's definition. And also, and I think Hector will be dealing with this, but with regard to the Europeans markets in crypto assets regulation as well, which state that crypto assets are a digital representation of value which may be transferred and stored electronically using digital ledger technology or similar technology. I say that mainly because you have this kind of very broad definition of crypto assets, and I'm just focusing on crypto assets, and that alone, you've got a kind of different categories in which they can fall. So they can fall into either exchange tokens, they're like, whether you have the pure cryptocurrency like Bitcoin, Litecoin, etc., where there is no utility except for providing a means of exchange on a distributed ledger. Then there's things like e-money tokens, which of course meet the definition of electronic money and the electronic money regulations of 2011 broadly. And these digital payment instruments that store value can be redeemed at par value at any time and offer holders a direct claim on the issuer. Then there are utility tokens. Now, utility tokens have a function which will be built into the token. For example, a utility token may enable a token holder to access a service or a product, such as an online storage space or digital marketing space, etc., whatever. So you've got those kind of utility tokens. Then you've got things like the security tokens, which are categorized akin to specified investments, like a share in debt instruments or are set out in the UK regulatory registration. Broadly, these are like to be tokenized digital forms of traditional securities. Then we have stable coins, which are backed by fiat currency or commodity or adjusted algorithm in that way. And of course, you've got non-fungible tokens. And then you can have a variation or a combination of these as well. So you can have a complete variety of these. And it's kind of difficult to assess exactly which umbrella the actual token fits in regarding their unique characteristics. So, I mean, in terms of regulation, we have, of course, these unique characteristics of being intangible, cryptographic authentication, the use of digital transaction ledger, the decentralization, and of course, rule by consensus as well that can be put into it, although there are questions as to regarding whether this rule by consensus is really still having an intermediary involved in all of this. So you have all these concerns, as well as apart from the variety of tokens, which are actually rapidly growing in this landscape and the uses for them. Then we have crypto assets that appear to exhibit certain properties of money or commodities and electronic payments. And their classification can be heavily contested as to whether they should be regulated or not. It's very unclear. So you have those kind of concerns. And then you have the cross-border reach of crypto assets, means that the greater cooperation is required between national and international regulatory bodies to decide on this. And then we have a real concern with regarding identifying control and responsibilities, particularly when you use the blockchain or in this kind of area. So you have all these concerns for regulators, which really makes it very difficult. Now, in the UK, the FCA, of course, is the financial regulator on this side, and they specifically made it clear that crypto assets, such as like trading on the FTX platform, etc., won't cover consumers. And I think this was quite clear with regard to a lot of the other kind of risks that were purport. So a number of consumer protection issues which arise from the use of crypto assets, as the European Banking Authority has warned consumers who have bought crypto assets through the exchange platform may lose their money. The US Financial Protection Bureau has released a consumer warning bulletin beforehand, and so did the FCA to warn UK investors that they got little hope of recovery. And this they published and warned investors back in September about the fact that they should be wary of unauthorized FTX activity in the UK. And it acknowledged that the Bahamas-based exchange decision to file bankruptcy proceedings in the US court could also cause concerns for UK customers. And I think that started alerting a rethink about the regulatory framework here, and probably sort of, speeded up certain issues. And what I can really say at the moment is that there is this concern now if I say back in November, in November, I think on the 4th of November, a revised financial services markets bill has been proposed following a public bill committee stage. where several amendments were introduced. And one amendment introduced by the Economic Secretary to the Treasury, Andrew Griffiths, MP, seeks to make amendment to Section 22 of the Financial Services Act of 2000 by including crypto assets within the definition of investments. Now, that is a paradigm shift for the crypto industry. To date, there has been two broad frameworks to consider in relation to crypto assets. One has been the securities framework, which hinges on whether a crypto asset falls within the definition of a specified investment. So are they security tokens, etc.? And of course, stable coins are regulated as listed in the Financial Services and Markets Act. But then you have the anti-money laundering framework, which is concerned with whether an establishment is conducting certain exchange or custody activities from a place of business in the UK in which it is subject to registration requirements with the Financial Conduct Authority under the money laundering and terrorist financing and transfer of funds information of payer regulations, what we call the RAW regulations. The fundamental issue with this approach has been, firstly, that the majority of crypto assets are not securities. And secondly, that the money laundering regulations of 2017 do not apply to an independently operated non-UK subsidiary of a UK group selling crypto assets in the UK. So as such, it has been relatively easy to structure projects that fall outside the UK legal and regulatory system, bring crypto assets into the UK regulated parameter, therefore bringing this change, if the bill does go ahead, will bring crypto assets into the UK regulatory parameter before, therefore represents a major shift in the dynamics, and it will represent the first time where crypto firms cannot structure around a regulatory parameter. But there is a need for certainty. But the problem, as we say, is this really going to lead to a lack in innovation? It will be important to recognize that the nature of this industry, which has generally been startup led, and as such, if new regulations are too heavy-handed, there is a risk of accidentally hindering the growth of the industry. And in this respect, it's interesting to see how the balance is struck between the Financial Conduct Authority in terms of encouraging competition with new market entrants and protecting consumers. So you've got that balancing field going on ahead in there. I do want to just mention, as you mentioned, with regard to English common law, and if we've not heard about this, is of course a UK jurisdictional task force on the of the Law Tech Delivery Panel, which is a body established by the Secretary of State for Justice and chaired by the Master of the Rolls, Sir Geoffrey Wells, published a legal statement on crypto assets and smart contracts back in November 2019, and I'll put the link in the chat in a few minutes. But it's much needed. And the importance of that, in summary, was a legal statement identified that in general, crypto assets have all the indica of property, and that the novel and distinctive features possessed by crypto assets, the intangibility, the crypto authentication, etc., and the use of digital transaction ledger, etc., what I mentioned, do not disqualify it from being property. And I'll come to the importance and significance of why being to identify these crypto assets legally as property is very important when we take legal proceedings. But and also that crypto assets are not disqualified from being property as pure information, or because they might not be classified either as things in possession or things in action. And this is where the Law Commission has come into hand recently with their consultation on digital assets. And that they should be this year, 2023, I think it's going to be a real opening for a lot of these regulations and recommendations that are coming out. So legal statement itself. Sorry, am I right? Yeah.
No, I was just of time requesting you to conclude the summary of the UK position, and we can hear then see what's next. Sure.
Yeah. So the UK position at the moment is under reconsideration. As I said, the bill is there is one bill for proposals to try and see about investing. But I would say that the fact that crypto assets are capable, and I say capable, of being recognized as property under English law, however, is wide-reaching. Victims of fraud, theft of crypto assets have been able to obtain proprietary orders and obtain proprietary injunctions and freezing orders in the UK courts in order to try and restore and return their property.
Thank you. And yes, the news did reach us in 2019 itself about the LawTech panel and the important classification of all forms of crypto as property. And I think that is one of the key aspects, as you rightly pointed out, Shobana, as to how all legal systems, civil law or common law, will have to address this new asset class. But while the lawyers debate the jurisprudence of it, the very kind of animal spirits or the energy of industry is represented here on the panel by Suraj. So if I can turn over to you, Suraj, to talk to us about the entrepreneurial perspective that you see, despite these challenges of FTX today, something else tomorrow, 3 arrows yesterday. But overall, your approach and opinion seems to be that commercial viability of the crypto industry is only gaining. And what are some of the long-term benefits that you see to national or global economic activity that is contributed by the crypto industry? And therefore, over to you for further details.
Thank you so much. Thank you, Shobana. That was like a great overview of what the regulators are thinking. And trust me, the entrepreneurs are definitely not looking at this, but we feel that crypto can solve for all these concerns and more. Before I start, I want to acknowledge that probably crypto today is at a stage, a very, very early stage. I would say probably we go back to the era of automobiles getting invented. So before there were any automobiles, we had commute used to happen over horses, and horses were a great mode of commute. So there were no problems of drink and drive. There were very, very few accidents. The breakdowns were absolutely not there. So there's absolutely no reason to reinvent and bring in automobiles. But when the first set of automobiles started getting built, there were a lot of problems. So it required a license to operate this automobile. It required certain skill. It created issues which were solved over a period of time. But today, if we say, we can rewind our lives and say, can we go back to saying that we will not invent automobiles because it will create so many problems? You can see how economies have accelerated with automobiles. So holding that as a thought, and then bringing that to the internet and how internet has totally transformed the way we function. I would like to now go back to history and say that I was just having a conversation before starting this talk, saying the last big revolution which happened in the financial ecosystem was probably in the 15th century when double entry accounting system was invented in Italy. And the Medici Bank was the first bank which adopted double entry accounting system, which reduced frauds drastically. And but fast forward to the late 90s or early 2000s, people have figured out ways to circumvent double entry accounting system. There are a lot of frauds which have happened, beat Lehman Brothers, or you can take any fraud, it's like all accounting frauds. So what today crypto brings to the table is, for the first time in history, an immutable ledger. And I want to stress the word immutable here because this has never happened before in the history. And this ledger is not only immutable, it's also decentralized, as in it's a distributed ledger, it's a public ledger. So for a regulator, this should be great news because now they have all ledgers that are very private in nature. The first time we have a ledger, which is public in nature, which is distributed, these are multiple copies of it, and is accessible by anybody and everybody. The oversight need not be only by the regulators, the oversight can be by anybody. And for the first time brings out accountability, or any common man who has interest can participate in any kind of due diligence over any asset. So having said that, if you ask me like, okay, then how did things like FTX happen? How did things like Terra Luna happen? You wiped out billions of dollars over just 1 year. So how does this work? So there are two kinds of businesses today out there. One is businesses which are giving you access to crypto assets. Could be like FTX. There are a lot of Indian companies, could be like a WazirX, which we call centralized exchanges. Then there are a second set of businesses which use crypto as an asset class to follow Web3 as an ideology, which use blockchain fundamentally. Now, these are the businesses, or these are the companies I feel that are going to say that how can we truly adopt into an ideology where of non-custodial solutions. If you look at what happened in FTX, why it happened, what happened, was because of custody of assets, or who has control of the ledgers. The whole crypto movement is about that no centralized entity, be it the government or be it any single entity, should have control over the ledgers, because anybody who has control over the ledgers can modify the ledgers as per what they need. And regulation becomes that much more harder because the regulators can only see what you want them to see. Whereas once you have a public ledger and a distributed ledger, it can not only be validated by regulators, but it can be validated by common man. More importantly, it can be validated by code. If you see the advancements in technology over the last 25 years, be it India's contribution into advancement of technology or the American way of bringing in products, every problem is today tackled by technology. You can look at it, you can pick up any industry and say, how has technology revolutionized this industry? So, but if you look at what has technology done to finance, technology has done nothing to finance. So we today stand in a unique position where we are giving an opportunity for technology to revolutionize finance. And when revolutionize finance, I say that take us out of this suppressive economy which we are facing from last 20 years. So what I mean by suppressive economy is, if you look at the businesses which have thrived in the last 20 years, are all middlemen. So be it an Amazon, or be it a Facebook, or be it a YouTube, anybody who has made money are all middlemen. The true entrepreneur who can be creative does not have an asset class to be creative. Now, here is an opportunity where we say that there is an opportunity to bring in equal opportunity for every single person to access any asset class. Today, if I have to invest in a few funds, I need to be an affiliate investor. I need to take an opportunity in another country. There are 20 regulations that are preventing from it. Forget doing any of those things. I need to do it. I need to travel to another country and I need to transfer money. I need to cut through so much red tape. So entrepreneurship doesn't work with restrictions. Entrepreneurship works with freedom and letting entrepreneurs be creative. I would like to quote, I was in this conference and Chris from Anderson Horowitz, who's an evangelist and who brought in the Anderson Horowitz crypto practice, was speaking about how there can be at least $50 trillion companies which will come up in the next 10 years. And all these companies are today at zero. And that's the opportunity we are looking at. If we are able to ease the economy and say that we want to give entrepreneurs the freedom to operate. So this is where we are standing.
Thank you, and thank you for your succinct and enthusiastic comments. I will invite you to reflect on a question which you can answer later, because some of this activity that you speak of enthusiastically perhaps has a few presumptions on the availability, for example, of semiconductors, of hardware, of energy, and a whole bunch of real-world needs that are required to sustain the levels of creativity that you speak of in this bright crypto future. I will invite you to reflect on it while we come back. Meanwhile, the prompt of this entire discussion has been FTX. FTX, an exchange which has been a spectacular collapse, and several aspects have been covered, including the sociological, political, financial. But today here we're looking at some of the legal aspects of the FTX collapse. So may I invite Emmanuel to please lay out what really happened in FTX, and more importantly, what efforts have been there to retrieve and locate assets in a multi-jurisdictional approach, which sometimes does not get precedent. Emmanuel.
Yes. Good evening to everyone. Good afternoon, and it is early, as Shreya has mentioned. I will, with your permission, Shreya, I will share my screen just to share a few visuals for everyone to see.
Sure.
I guess the host has disabled my screen sharing, but if you may arrange it, I will just. Thank you. Just while we set up the screen, I wanted to share me a little bit of my experience, not in precisely to the legal matters, but just the commercial aspects of some clients that have brought the opportunities of crypto to our attention in the last couple of years. We've had different approaches from, I guess, as Suraj was saying, how can tech revolutionize finance? We have received certain queries, even from Latin American entrepreneurs, in trying to establish crypto trading platforms for servicing clients in Central America and Latin America, which has been very eye-opening to see and to understand the tolerance of risks that certain investors and certain entrepreneurs are taking in order to diversify their portfolios. That came to our attention. I guess you can see my screen, right?
Yes, we can.
Okay. That is one type of question that we received. This is interesting because this was new. This came to us the first time maybe two years ago. And I guess also the other extreme part of it is that during December of last year, we were negotiating a case for a client of ours, and we received this counterparty who is a debtor to our client and who offered to pay off his debt in crypto. This opened our ears. I mean, our client is pretty conservative to risk. He's a South American branch of a big multinational company. And the debtor came up and said, listen, the only way I can bring this money and pay you today is through crypto. I guess what he added there during his second intervention just red flagged his intentions, because at some point, Latins are still conservative to these types of transactions. And especially when it comes to people who are not of their entire trust, and especially when you see things such as the FTX recent crashes that have occurred and the whole contagion that occurred after that. They did not conduct their payment in crypto, but this was certainly something very interesting because we can see that the market is moving. I will make a good efficient use of your time. I will just put some visuals for you to see and comment on this to direct your attention to some interesting facts and numbers that I have put together for you to appreciate. First off, as an attorney, I would just like to say and just give a brief disclosure that I'm not a professional investment advisor, and therefore we recommend that everyone seek a duly licensed professional for investment advice. This is lessons learned from the past, even through different collaborations. Even if you see the principles involved in these type of cases, they somehow they go around acting as if they are professionals, but there are persons who are better informed than us to provide with investment advice for particular situations. I would like to start off. I like what Suraj mentioned, and it is important to see first and to understand that not just the crypto trading platforms, but the digital asset world has a purpose. It has a benign purpose, a purpose to diversify options for investments and to buy, to sell, to trade, to receive a loan or to loan. And we see some dynamics in the market ever since the crash of the FTX back in November of last year. It has only been a couple of months after that, but this was reported today by CoinDesk, which just comes to my attention that the big hit that this took was during the end of the year, got also intermingled with different recoveries around the world that came from COVID, the inflation pressures that have been staggering, and the pressures, the economic pressures that different governments have been facing due to the release of certain measures adopted by the pandemic. But I guess this will bring back a new world and a new hope for the use of digital assets, and our understanding as well of the opportunities behind them. I just wanted to kick off with that because it's important to understand that these do have a purpose. And there are some people that misuse this purpose for other reasons. And to my appreciation, this is what happened at FTX. If we go to the crash itself, we will see first that you could see the signs that were coming through different channels, especially if you go to social media just days before the crash. You could see first, you have several competitors of crypto trading platforms, maybe spreading correct information, wrong information. But you can see the principle here of FTX trying to ease everyone down and saying that the assets are fine. These red alerts to any informed advisor, informed investor, are very important in order to secure a position in trying to ascertain their understanding of where their investments are. Right, and this took a turn a few days after. If you see, this tweet is from November 7th, but this took a turn some days after, where the crash actually took place. If you see, what made news around the world was the filing of for bankruptcy of a company that was with a principal place of business in Bahamas. And the company's name is FTX Property Holdings. Most news outlets during these dates who published this information started spreading the news around that there were big concerns on FTX property and the contagion effect that subsequently it had in the following days. However, I guess this was one of the first surprises that came out because FTX had positioned itself very importantly in the minds of American consumers. Through different sponsorship deals, different celebrities that use the brand, and there are even sports teams who have accepted sponsorships from FTX. So this was big news. That was spread across, first from my side on the Western Hemisphere, from America, and then just made its way all over to Europe and the islands and Asia, and all the impacts that it hit around the world. We will see more of this further. As you can see in the filing really portrays very large number of creditors, assets, liabilities. It just comes to your mind that this is endless. Something big happened here. There are large amounts of money involved, and there are many people involved, which will now face a problem. As investors, when you go and try to seek these filings, these are public documents that you can obtain. You can gain a grasp of what size of a problem your investment might be in. And this may guide you to hire the correct professional in order to assess you in every step of the way. This is what we attorneys would like to say, like a 24-hour emergency thing that you have to be reactive and try to understand in order to move forward and try to secure your patrimony. After the collapse and after the US announced this, you could see the reactions in several places. For example, if we are talking about Bahamas, you could see that the Securities Commission of the Bahamas, the regulator, actually set a foot in the story. They sought the appointment of a provisional liquidator, and after that they started informing the public. They are still doing that because the FTX Digital Markets entity and other entities are based and constituted in the Bahamas. So you could see the commission taking a lead authority in conducting this investigation. Will just was news just coming out of 3 days before, on a Friday, that it was announced that in the US the process had already started. This is, I will not go through these details, but The red flags were there just prior to the Chapter 11 voluntary petition. You could see that not just liquidity was a problem, but also the leadership of the trading platform was also in question. And from there, you could see that professionals were hired to do the job, and appointments were made in different jurisdictions, and then the house came crumbling down slowly. Furthermore, so just to give you an idea of what the largest or the most exposed creditors were according to the initial filings that were made, you could see that the top three here are just big numbers on unsecured claims. Just gives you an idea of how concentrated the portfolio was, and just the size of the deal and the engagement that the restructuring professionals had to go through in order to clear up the arena here. After that, as you may be aware, the criminal side of the case came over, and there's attention brought to the fact that the principal of FTX was arrested and was sought for extradition by US authorities. In fact, the US authorities initiated a process against him, mostly on counts of wire fraud, different types of wire fraud, money laundering, and even illicit electoral campaign financing. This is very interesting because this is how the Ponzi scheme or the fraud came to develop, not just because of the misuse of funds and the lack of representations, but also the use of these funds afterwards, which would lead us to the tracing exercise. I will move in a little bit faster. What is the nature of the FTX? The concept has evolved, being from a simple company founded in 2019 in order to become a centralized digital asset exchange, positioning itself very strongly, at least in the USA, as far as I'm concerned.
Sorry, but in the interest of time, could you take us to the asset recovery and pricing? Because there may be a couple of minutes that we'll bring Hector in.
Okay. May gladly. I will move forward to the assets. This is, as already mentioned, the implications of having a very widespread multi-jurisdictional case come to different attempts and different professionals to initiate efforts to retrieve the assets that were lost in the fraud. The first thing that you can see from the filings is that there was a mapping of the entities and the commercial aspects and activity of each of the entities in order to classify them and understand where the assets were directed to, what the initial purpose of the assets were. This is a figure that comes out of the filing from and the first declarations from the CEO, which are in the file. As you can see, there are different activities here: BlockFi loans, NFTs, gaming as well, capital markets, derivatives. And you can see that if you would set up to classify the different aspects of this case, this is how it was divided by themes and by topics. And from our experience, which is the challenges of retrieving the assets, and then I will leave the microphone to the next speaker who may complement on this. The first attempts have been to work with teams of professionals specialized to secure the assets were located. I put, this is not a limited list, but this is what at least has been done in this case and what I've reviewed that the professionals have done. At least you would have these 4 types of professionals in order to assess every type of implication of the tracing exercise, not just the legal part, but also the investigation, and which is something that is very important, is trying to trace back how the transactions took place. And that's why you would put in place cybersecurity experts. And finally, to finalize my initial presentation, this is also a very important objective for the case, and very important for you as interested persons in digital assets, investors, potential investors, or managers of portfolios. If you would reverse the case and go from the end to the beginning, you would see that the objectives here of any exercise in tracing your asset, and this is a table for you to measure you with. First, we would seek that there is value, right? And then we will seek an efficient approach to recover these assets. I wanted to sum up these ideas for you, Shreyas. So thank you for the space, and we'll be gladly sitting here to listen to our other colleagues and any questions that the panel may have.
Thank you, Emmanuel, for accomplishing a very difficult task of compressing the FTX intricacies into just a few minutes. But without further ado, we have Hector, who's been standing on patiently. Hector, if you could please draw further attention to the asset tracing options that are available more generally, beyond even FTX, but also how FTX has shown it in all parts of the world. And one figure that perhaps Emmanuel did not mention because of speed is that even the bankruptcy filing included 130 entities, right? And it was across several countries, including, I remember seeing an entity in Senegal. And so there's this impression, Hector, that if one were to structure in a way that far off and difficult to encounter jurisdictions, that somehow you are able to successfully hide an asset. And that may not be true. So Hector, over to you.
Yes, thank you very much. I think it's very interesting to compare the asset tracing tools that exist in different parts of the world, especially comparing the common law approach and the civil law approach. The common law approach, from what I understand, is for asset tracing and recovery is based on civil actions and also is based on cross-border insolvencies like the one we see here with FTX. The civil law approach, which is the one that my jurisdiction belongs to, Spain is a civil law jurisdiction and a member of the European Union, is a little bit different. We normally use criminal proceedings to deal with it, only to deal with this kind of fraud. Why? Because criminal proceedings in continental jurisdictions have a much wider scope than they have in common law jurisdictions. In a civil law jurisdictions, victims of fraud have legal standing to start private prosecutions, to start a criminal case against the fraudsters. And that is generally not the case of civil law jurisdictions, where victims of fraud do not have this kind of legal standing. It depends on the jurisdiction, and I'm not a common law attorney, so I cannot go deeper into that. Maybe Shobana can provide more details about that. But I think that this is fair to say that this is one of the basic distinctions. If you look at the criminal fraud case against Sam Bankman-Fried in the United States, you will see that it has not been started by victims. It has been started by the Department of Justice. This is a different approach from the one we have here in continental Europe and certainly in Spain. So the cases that we have seen here in Spain, particularly dealing with crypto fraud, crypto scams, of course, there are much simpler situations than the FTX case. The FTX case is very complex. You don't know if it's a simple Ponzi scheme or it's a case of fraudulent mismanagement. It's still unclear the nature of the behaviors that have led to this result. But this is completely extraordinary. What we are used to see here is simple Ponzi schemes, pyramid schemes. You go on the internet and you see an investment, a web page, putting together an investment platform, inviting you to invest normally in a cryptocurrency. So, hey, you can buy Bitcoins and we assure you that you will have an amazing return. And so you start making a small investment and you start getting monthly recurring payments in exchange for your investment. And then word spreads out. A lot of investors come in, but there's actually no investments behind. There's no actual returns behind this scheme. It's just that customers are paid with the money that the new investors coming into the platform are providing. So there is no real return here. So it's a very typical Ponzi scheme. And this is something that we have seen both with cryptocurrencies and also with other, like Shobana was saying, with other sort of crypto assets, specifically with utility tokens linked to Ethereum-based blockchains. And one specific case that our firm is dealing with currently is called the Quailian case. The Quailian platform gave customers the possibility to invest in the master node of a Ethereum-based blockchain. What is a master node? A master node is a super node. And what is a node? Is a computer. Each computer that is logged into an Ethereum-based blockchain is called a node. And a master node is a super node, is a supercomputer that provides services to the rest of the nodes, basically validating transactions over that blockchain. I'm trying to summarize in very simple terms what is probably a complex situation, and if you've never heard of it, it might be difficult to grasp, but think of a supercomputer that provides services and gets paid for those services. Now, the trick about this is that since it is Ethereum based, in order to become a master node, you have to, it's an Ethereum blockchain, so it follows the proof of stake standard. So to become a master node, you have to prove that you have enough stake in the platform, meaning that you have bought an enormous amount of Ethereum-based tokens with which this blockchain runs. So the trick here is, hey, we are a pool of investors. Give us your money. We are going to invest in this master node. We're going to be thousands of people putting together thousands of dollars, and we're going to invest them in these master nodes. We're going to transform them into Ethereum. We're going to buy those utility tokens. We're going to become master nodes, and the mini nodes in the blockchain are going to pay us for the services that we're going to provide to this blockchain. This is more or less the situation. So the investors that put their money into this Quailian scheme all of a sudden stopped receiving payments. They started a criminal action. And what is funny about this situation is that the defendants said, hey, you don't understand. This is not a scam. This is not a fraud. This is an investment. This is an investment that has gone wrong because there were not enough nodes, blah, blah, blah. So we're now moving from a criminal perspective where we think it's a Ponzi scheme, and the defendants very cleverly are saying, no, no, this is an investment. You didn't understand anything. And sometimes investment goes sour. I'm sorry, you lost your money. I'm sorry, just like Mr. Sam Bankman-Fried is used to say. So, so just to tell you that we are going into uncharted territory, and the kind of legal arguments that we are facing with this kind of situations is new. I don't know if you have noticed that Sam Bankman-Fried has just become a blogger. He has opened a blog. I mean, he is under criminal prosecution. He has the right to remain silent, but he has chosen to start a blog. And in this blog, he's now trying to convince us that everything is perfect, that everything was fantastic, but that, you know what, I'm sorry, bad things happen, and I'm so sorry, basically. I'm sorry, and I'm sorry you lost your money, and I'm sorry I was a bad manager, but no fraud here, no fraud here, just a case of bad luck. So, so this is the kind of legal arguments that we're going to face. And at the same time, in terms of asset tracing tools, of course, in a criminal proceedings in continental jurisdictions, you have the kind of disclosure orders, freezing orders that you are used to see in common law civil proceedings. So you have a huge array of tools at your disposal, including the support of police. in most continental jurisdictions, police departments are opening specialized sections devoted to prosecute technology-based crimes. And I must say that here in Spain, those sections are quite efficient. They're quite competent, and so of course you obtain a great deal of support from the court, from the police, to try and trace those assets. Another challenge here is obviously the cross-border nature of this kind of situations, where of course within the European Union we have a very strong cooperation between courts, criminal courts and police departments, etc. But once you move out of the European Union, like is the case in this kind of crypto scams, you never know. You have to rely on mutual legal assistance treaties that may or may not exist with the jurisdiction of interest. So we must say that cooperation, judicial cooperation in this kind of matters is not easy. And so the possibility to obtain actual results is quite a challenge in terms of asset tracing and recovery. And I would also like to mention that, as I was saying at the beginning, it is, at least I have not seen it, it is rare in continental jurisdictions to have insolvency proceedings open against this kind of exchanges or platforms, because we follow EU law, and EU law only gives jurisdiction to insolvency courts when the platform, when the crypto platform has its center of main interests in the local jurisdiction. So it's not possible, or it's extremely difficult, to be more precise, to open an insolvency proceedings in Spain, for example, like the one you have seen in the United States, involving FTX and 130 subsidiaries all over the world. It's very unlikely and very difficult to see and to obtain. That is why insolvency proceedings are not the kind of tool that we see being used to fight this kind of fraud. And I will leave it here.
Okay, thank you very much again.